General provisions.
Section 248. Juries, number of jurors, 3/4 may indict or give verdict. A grand jury shall consist of 12 persons, 9 of whom concurring, may find an indictment. In civil and misdemeanor cases, in courts inferior to the circuit courts, a jury shall consist of 6 persons. The General Assembly may provide that in any or all trials of civil actions in the circuit courts, 3/4 or more of the jurors concurring may return a verdict, which shall have the same force and effect as if rendered by the entire panel. But where a verdict is rendered by a less number than the whole jury, it shall be signed by all the jurors who agree to it. The American jury at the start of the 19th century was a celebrated institution that supposedly guaranteed liberty, yet by its end had become a controversial institution that allegedly encompassed permissiveness and ignorance. Critics charged that criminal juries especially contributed to a growing crime problem in the nation and Kentucky by too often acquitting the guilty, or at least letting them off with too light a sentence. They pointed to the necessity for a unanimous verdict as a particularly deficient feature of the jury system, which too often produced hung juries, arbitrary and ridiculous compromise verdicts, miscarriages of justice, and corrupt jurors. Despite these complaints about the criminal jury, the framers of the current Constitution created the possibility of a non-unanimous verdict only in civil cases, 3/4 or more, if the General Assembly so provided by statute. They also joined a growing number of states by providing for 6-member juries in misdemeanor and minor civil cases. Pursuant to Section 248, the General Assembly in 1892 by statute declared that a valid verdict in a civil case required only a 3/4 majority. The Kentucky judiciary has ruled that in personal injury trials where juries have to make specific findings on certain issues of negligence, the same 9 jurors do not have to agree on each finding, in Young v. J. B. Hunt Transportation Incorporated, 1989. The courts have also ruled that the presence of a stenographer in a grand jury room does not violate Section 248 in Alford v. Commonwealth, 1931, but that an indictment by a grand jury of more than 12 members does, in Downs v. Commonwealth, 1892. Further, a person on trial for a felony may agree to a trial by a jury of fewer than 12 persons, although the court did not establish how many fewer, in Short v. Commonwealth, 1975.
Section 249. Employees of General Assembly, number and compensation. The House of Representatives of the General Assembly shall not elect, appoint, employ or pay for, exceeding 1 chief clerk, 1 assistant clerk, 1 enrolling clerk, 1 sergeant at arms, 1 doorkeeper, 1 janitor, 2 cloakroom keepers and 4 pages. And the Senate shall not elect, appoint, employ or pay for, exceeding 1 chief clerk, 1 assistant clerk, 1 enrolling clerk, 1 sergeant at arms, 1 doorkeeper, 1 janitor, 1 cloakroom keeper and 3 pages. And the General Assembly shall provide, by general law, for fixing the per diem or salary of all of said employees. The convention delegates inserted this provision to stop the practice of legislators hiring members of their families as pages and other employees, a habit that allegedly created congestion from the presence of too many of these employees and unnecessary expense. To save future legislators from the embarrassment of having to deal with numerous job requests and also to save expense, the delegates established specific limitations on the number of well-defined job categories. The Kentucky judiciary has ruled that both houses of the General Assembly must strictly observe the limitations contained in Section 249 and may not hire help not specified in this section, in Walker v. Coulter, 1902, but that the section does not create positions that need to be filled, in Shanks v. Howes, 1926. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 249.
Section 250. Arbitration, method for to be provided. It shall be the duty of the General Assembly to enact such laws as shall be necessary and proper to decide differences by arbitrators, the arbitrators to be appointed by the parties who may choose that summary mode of adjustment. In the latter part of the 18th century and the early part of the 19th, radical members of the Republican Party, the party of Thomas Jefferson and James Madison, favored reforms that simplified the legal system and reduced the power of lawyers and judges. The General Assembly adopted one of the favorite reforms of radical Republicans in 1795 and 1798, when it enacted arbitration statutes that enabled parties involved in a legal dispute to submit their disagreement to arbitration by arbiters who did not have to be lawyers. The framers of the Second Constitution endorsed this reform when they inserted in the Charter a requirement that the General Assembly pass such laws as shall be necessary and proper to decide differences by arbitrators, to be appointed by the parties who may choose that summary mode of adjustment. Instead of enacting new legislation, the General Assembly allowed the old statutes to continue in force. The drafters of the Third Constitution incorporated the same language as in the Second Constitution into its general provisions, but they rejected a proposal to establish specific institutions of arbitration, to be known as courts of conciliation. After the adoption of the Third Constitution, the General Assembly enacted a statute that incorporated many of the features of the previous legislation. In 1984, the legislature passed a more modern statute that made agreements to arbitrate valid, enforceable, and irrevocable. In the only decision of significance involving Section 250, the Kentucky Court of Appeals ruled that the provision helped validate the Workmen's Compensation Act of 1916, because the members of the Workmen's Compensation Board were arbitrators and therefore could be constitutionally established by the General Assembly to settle disputes arising from job-related injuries, in Green v. Caldwell, 1916.
Section 251. Limitation of actions to recover possession of land based on early patents. No action shall be maintained for possession of any lands lying within this state, where it is necessary for the claimant to rely for his recovery on any grant or patent issued by the Commonwealth of Virginia or by the Commonwealth of Kentucky prior to the year 1820, against any person claiming such lands by possession to a well-defined boundary under a title of record, unless such action shall be instituted within 5 years after this Constitution shall go into effect, or within 5 years after the occupant may take possession. But nothing herein shall be construed to affect any right, title or interest in lands acquired by virtue of adverse possession under the laws of this Commonwealth. Section 251 represents an effort to settle the ownership of land, title to which had originally been granted under the laws of Virginia prior to Kentucky's statehood or before 1820 under the laws of Kentucky. Many individuals claiming ownership of Kentucky land under Virginia grants had never actually settled their land, which often had been occupied by Kentucky squatters. The Virginia Compact of 1789 provided that all Virginia law grants would remain valid following Kentucky statehood. And in 1823 the South Supreme Court declared unconstitutional a subsequent Kentucky law that favored Kentucky occupants over those claiming lands under Virginia grants, in Green v. Biddle. Then, in 1831, the court further confused the issue by upholding a Kentucky statute of limitations designed to protect Kentucky occupants over absentee owners claiming title from Virginia, in Hawkins v. Barney's Lessee. Despite this latter holding, Virginia land grants and pre-1820 Kentucky land grants continued to cloud the titles to Kentucky land. A condition Section 251 was designed to remedy. Section 251 in effect provides that a person claiming title to land by virtue of a title granted after 1820 and who has occupied the land will prevail after 5 years have elapsed from the time the Constitution goes into effect or 5 years after the claimant takes possession of the land against one who claims title under a pre-1820 Virginia or Kentucky grant, but has not occupied any part of the land in dispute. Until 1940, the Kentucky Court of Appeals seemed to undermine Section 251 when it held in a series of cases that despite the constitutional provision, absentee owners claiming title to land under a Virginia grant should prevail over occupants claiming title under a later Kentucky grant. However, in 1941 the court reversed itself and ruled that in such a conflict, Section 251 gave title to occupants under later grants, in Warfield Natural Gas Company v. Ward.
Section 252. Houses of reform to be established and maintained. It shall be the duty of the General Assembly to provide by law, as soon as practicable, for the establishment and maintenance of an institution or institutions for the detention, correction, instruction and reformation of all persons under the age of 18 years, convicted of such felonies and such misdemeanors as may be designated by law. Said institution shall be known as the House of Reform. Section 252 represents another example of the Constitution mandating legislative action because the framers did not trust the legislators to pursue the objective themselves. The objective was the establishment of a reformatory for the incarceration and reform of adolescents convicted of crimes that called for some sort of confinement as punishment. By the end of the 19th century, most states, except those in the South, had established reformatories. Supporters of Section 252 argued that it was necessary, because the General Assembly had established a reformatory in 1872, but then converted it to a mental asylum in 1873, and could not be relied upon to create another one without a constitutional mandate. They submitted that the establishment of a reformatory was necessary, because adolescent criminals should not be confined in a penitentiary with older, more hardened criminals who would only have a bad effect on the younger prisoners. Because they feared the effects of imprisoning adolescents with adults, Kentucky juries traditionally manifested leniency toward younger criminal defendants and often acquitted or simply fined them. The General Assembly did not establish reformatories until 1896, but the Kentucky Court of Appeals ruled that this delay did not mean that in the interim, a trial judge had no authority to order a convicted 18-year-old to serve a sentence in the penitentiary, in Willard v. Commonwealth, 1894.
Section 253. Working of penitentiary prisoners, when and where permitted. Persons convicted of felony and sentenced to confinement in the penitentiary shall be confined at labor within the walls of the penitentiary, and the General Assembly shall not have the power to authorize employment of convicts elsewhere, except upon the public works of the Commonwealth of Kentucky, or when, during pestilence or in case of the destruction of the prison buildings, they cannot be confined in the penitentiary. That Section 253 of the Constitution be amended so that the Commonwealth of Kentucky may use and employ outside of the walls of the penitentiaries in such manner and means as may be provided by law. Persons convicted of felony and sentenced to confinement in the penitentiary for the purpose of constructing or reconstructing and maintaining public roads and public bridges, or for the purpose of making and preparing material for public roads and bridges. And that the Commonwealth of Kentucky may, by the use and employment of convict labor outside of the walls of the penitentiary by other ways or means, as may be provided by law, aid the counties for road and bridge purposes, work on the state farm or farms. In 1880 the General Assembly, by statute, authorized the leasing of convict labor to private contractors for work outside of the penitentiary walls on railroads, canals, waterways, and levees. In 1884, the legislature permitted private contractors also to work convicts in coal mines. The leasing of convict labor outside prison walls discontented the public, some of whom argued that it raised little money for the Commonwealth, unfairly competed with free labor, especially coal miners, and subjected convicts to often inhumane treatment at the hands of the contractors. In response to this discontent, the General Assembly enacted a statute in 1886 that forbade working prisoners outside of the prison walls once the existing leases had expired. To ensure that the legislature would never again authorize unregulated, outside the walls leasing, the framers of the current Constitution approved Section 253, which prohibited prisoners from working outside the penitentiary except if authorized by the General Assembly, on public works of the Commonwealth or in cases where pestilence or destruction made it impossible to house convicts in the penitentiary. They inserted Section 254 to ensure that prisoners working outside the prison walls would be under the control and care of the prison officials rather than a private contractor. In 1915 voters approved an amendment to Section 253, consisting of the second paragraph, that empowered the General Assembly to permit prisoners to work on the public roads and bridges, including county roads and bridges, to make materials for roads and bridges, and to work on the state farm or farms. Governor James B. McCreary urged the General Assembly to propose the amendment because of public demands for improved roads and public support for the use of convict labor to achieve this objective. In 1916, the General Assembly enacted a statute that authorized the use of convict labor on highways, but it repealed the statute in 1922 after a schoolteacher was allegedly killed by a convict near a labor camp. In 1926, the General Assembly enacted another statute authorizing the use of convict labor on state highways, but the program it initiated was abandoned as unworkable in 1935. There have been very few published decisions concerning Section 253, and those few occurred either late in the 19th or early in the 20th century. In the most relevant of these, the Kentucky judiciary held that Section 253 did not invalidate the parole law, in George v. Lillard, 1899. However, in 1984, the Attorney General issued an opinion arguing that a Kentucky statute that authorizes the Secretary of the Corrections Cabinet to permit trusted prisoners to have daytime jobs in the community violates Section 253. The Special Commission on Constitutional Review of 1987 recommended that Section 253 be amended to read that persons convicted of a felony and sentenced to confinement in the penitentiary shall be confined in a state penitentiary except that the Commonwealth of Kentucky may use, employ, or lease the services of such persons outside of the penitentiary in such manner and means as provided by law. The Commonwealth shall maintain control of the discipline and care of the convicts to ensure security of the prisoners and of the general public.
Section 254. Control and support of convicts, leasing of labor. The Commonwealth shall maintain control of the discipline, and provide for all supplies, and for the sanitary condition of the convicts, and the labor only of convicts may be leased. One of the purposes of Section 254 was to ensure that a state official would be on the job with the convicts leased by private contractors to guarantee that the convicts were not mistreated or overworked as they often had been. The achievement of better living conditions within the penitentiary constituted another objective of Section 254. The Kentucky Supreme Court has held that Section 254 and statutes enacted pursuant to its authority impose a duty on the Kentucky Corrections Cabinet to accept for confinement in state prison convicted felons being temporarily housed in county jails, even if the state prisons are overcrowded, in Campbell County v. Commonwealth, 1988. In the opinion of the Attorney General, Section 254 does not authorize the Commonwealth to contract with a private enterprise to operate a residential correctional center free from the supervision, administration, and disciplinary control of correctional officials. The Kentucky Court of Appeals earlier held that Section 254 authorizes the state penitentiary then located in Frankfort to ignore a Frankfort City ordinance regulating the sale of milk within its boundaries and to purchase milk that had not been inspected by local officials, in Board of Councilmen of the City of Frankfort v. Commonwealth, 1932. The court also held that Section 254, together with Section 253, authorizes the Board of Prison Commissioners to lease to a private company the labor of convicts within prison walls and under the disciplinary control of prison officials. In Reliance Manufacturing Company v. Board of Prison Commissioners, 1914. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 254.
Section 255. Frankfort is state capital. The seat of government shall continue in the city of Frankfort, unless removed by a vote of 2/3 of each house of the First General Assembly which convenes after the adoption of this Constitution. The first Constitution required the General Assembly to appoint commissioners to select a site for the Commonwealth's capital, and they chose Frankfort. The Constitution also specified that 2/3 of all the members of each legislative house could move the capital. The second and third constitutions provided that Frankfort should continue to be the capital, but likewise provided that 2/3 of all the members of each legislative house could relocate it. The delegates to the convention that drafted the current constitution waged a spirited battle over Section 255. Those who favored moving the capital to Louisville, Lexington, or some other place supported a provision that mandated a statewide referendum on the question. However, those who favored keeping Frankfort as the capital supported a provision that required the settlement of the question, once and for all, in the next session of the General Assembly, and argued that the provisions in the first three constitutions that empowered 2/3 of each legislative house to relocate the capital created enough uncertainty to prevent the General Assembly from voting sufficient funds to construct an adequate state capital, governor's mansion, and other necessary state buildings, and that therefore there needed to be a final determination of the issue. The pro-Frankfort version prevailed, and the first session of the next General Assembly failed to vote to relocate the capital. The Attorney General cited Section 255 to support an opinion that a state employee was not entitled to reimbursement for expenses incurred for travel within Frankfort, as the statute authorizing reimbursement excluded travel within the seat of government.
Section 255A. Personal right to hunt, fish, and harvest wildlife, limitations. The citizens of Kentucky have the personal right to hunt, fish, and harvest wildlife, using traditional methods, subject only to statutes enacted by the legislature, and to administrative regulations adopted by the designated state agency to promote wildlife conservation and management and to preserve the future of hunting and fishing. Public hunting and fishing shall be a preferred means of managing and controlling wildlife. This section shall not be construed to modify any provision of law relating to trespass, property rights, or the regulation of commercial activities. The Kentucky Hunting and Fishing Question, also known as House Bill 1, was a legislatively referred constitutional amendment on the November 6, 2012 general election ballot in the state of Kentucky, where it was approved. The measure protected the right of residents to hunt and fish in the state. It was sponsored by Representatives Leslie Combs and Greg Stumbo. The measure was proposed in order to mandate that hunting and fishing should never be outlawed in the state without the vote of the people. The measure was introduced in Kentucky's 2011 legislative session. According to Stumbo, that's a big step, I think, in the right direction to help not only this generation of sportsmen but the next. We have a wonderful heritage of sports in this state. Kentucky was and still is the happy hunting ground. The measure passed by a margin of 85% for, 15% against.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.